Good evening, everyone. My name is Kiran Patel, and I am a financial planner and advisor at TMFD Financial. I would like to start off by thanking you for joining the webinar this evening titled Risk Management and Legal Issues for New Practice Owners. In a moment, I will introduce our presenter, Mr. Matthew Wilton. First, I would like to briefly introduce TMFD Financial and explain the valuable services we provide to our clients. Our goal is to make the financial lives of our dentist clients simpler by combining a variety of services under one roof, from tax, investment, insurance, and other financial planning matters you may have. In our experience, we found that providing a one-stop shop for financial solution provide client with the comfort of knowing that all aspects of their financial career are synchronized. The result is simplicity, peace of mind, and confidence in your financial decision. For those new to TMFD, I wanted to mention a couple of offerings that might be of your interest. For practice owner, we have the dental practice assessment and financial review. This process highlights the financial health of your practice, identifies the areas of excellence and the areas of improvement, as well as an estimated value of your practice. This is a service we offer to our all existing clients. So if this is of your interest, feel free to contact us. For associate looking to purchase a practice, we help guide you through the process. This includes a review of the practice, cash flow, and loan repayment projection, as well as identifying the areas of strength, potential areas of concern within the practice. TMFD has experience in helping dentists with buying and selling practices. More detail about both offerings will be provided in an email following this presentation. At this point, I would like to hand things over to my colleague Chris Malloy, who is managing the technology for us and providing some housekeeping items.
All right, thanks so much, Kiran, and good evening, everyone. Welcome to the TMFD Dental Academy, and thank you very much for joining us this evening. As Kiran mentioned, my name is Chris Malloy, and I'm a senior advisor with TMFD Financial, and I'll be running the technology in the background this evening. But before we get started, I just wanted to take a moment to run through these housekeeping items. This webinar is scheduled to go until about 8 o'clock this evening. If you have any questions for Mr. Wilton during the presentation, please ask them in the question and answer section at the bottom of your screen, and they'll be answered at the end of the presentation. If you have any questions for me behind the scenes or something you'd like to comment on, please feel free to send a chat in the chat box. CE credits will be sent out within 2 weeks of this event, no later than April 1st. Lastly, we encourage you to register for our TMFD Dental Academy mailing list so you can stay on top and up to date with all our future webinars. That's all I have for housekeeping items for today. So Kiran, I'll throw it back to you.
Thanks, Chris. Okay, so I am very pleased to announce and excited to introduce our speaker this evening, Mr. Matthew Wilton. Mr. Wilton is a litigation lawyer specializing in health law. Mr. Wilton has been assisting dentists in employment law matters, principal associate disputes, and practice breakup lawsuit and arbitration for the last 35 years. As a litigator, Mr. Wilton has appeared before the RCDS Discipline Committee, the Ontario Divisional Court, the Ontario Court of Appeal, the Federal Court of Appeal, and the Supreme Court of Canada. In today's presentation, Mr. Wilton will offer guidance for both associates and practice owners with the advice to manage your professional and business risk. So, Mr. Wilton, from all of us here at TMFD, we would like to thank you for your participation, and I will turn things over to you.
Thanks, Kiran. Good evening, ladies and gentlemen. I'm just going to pull up my slides. So my presentation is called Risk Management and Legal Issues for New Practice Owners. So as a litigation lawyer and as a lawyer who advises dentists in respect of RCDS matters, over the years, I have assisted a number of dentists in setting up new practices in terms of the legal issues that they have to face. So I want to start there. So firstly, you need to leave your current associateship. So I'm going to assume that you have a signed written associate agreement with your current practice. And typically that agreement would have restrictions upon your ability to contact patients if you leave your position. And that's what I want to talk about. How do you do that? You have to give notice, first of all, and obviously I'm taking you through the component parts of the steps. If you have an agreement, it will likely have a legal requirement for you to provide a specific defined period of notice to the principal in the event that you leave. It's typically the notice period will be anywhere from 30 days to 90 days, depending on the agreement. And if you don't have an agreement, I still think you should understand that you have to provide reasonable notice. And what constitutes reasonable notice is a variable standard that will be driven very much by how long you've been there. If you worked as an associate for 20 years, you may have to provide more notice than if you've been there for a year. So what happens once you give notice? I think you should assume that principal will be where you're going, as this may impact the principal's practice goodwill. And what I mean by that is the patient base, right? So the goodwill is the patient base, and will always be worried about whether patients are going to leave or not. I want to talk about advising patients of your departure, because obviously we assume that you want patients to follow you, and you need to make sure that they know where you're going. The ability to advise patients of your departure may be significantly restricted by any associate agreement that you've signed. So aside from any legal restrictions flowing from the associate agreement, the RCDS also provides direction and guidelines with respect to what they call a change in practice ownership. So here's the change of practice ownership practice advisory document. And it's interesting because the RCDS expects an associate to let patients know that they're leaving. So this is an excerpt from the guideline, and it simply says, when there's a breakup of a principal-associate relationship, it is a good idea to inform patients of these changes prior to the next scheduled appointment, so there will be no surprises when they attend. So according to the RCDS, they suggest that it's your ethical obligation to do so. And the professional misconduct regulation under the Dentistry Act provides further guidance what you're supposed to do. It's section 6 of this regulation. And what it essentially says is when the associated member and the principal members cease to engage in practice together, a principal member shall provide to any patient who requests it the business address and telephone number of the associated member, provided the principal member has or could reasonably obtain the information. And that's very important to keep in mind, that the principal agreement says has a legal obligation to tell patients who ask where you've gone, no matter what. So if they're not doing that, there's a problem. And then sub B says the associated member shall provide to patients the business number. Principal, that's not so interesting. And C, this is the interesting part. Except as otherwise agreed in writing, an associated member shall not solicit or permit the solicitation of the principal member's patients. This does not include sending out an announcement announcing the commencement or change in location of the associated member or partner's practice to patients treated by the associated member or partner, provided that the announcement contains only information to enable a patient the location and nature of the practice. This becomes extremely important because the expectation of the RCDS is that if an associate contacts patients and says they're leaving, that doesn't constitute a solicitation, and they expect you to do that. You have an ethical obligation to notify patients subject to any agreement. So this is the next bullet. 6 applies only where there's no written agreement which alters the obligations of the principal and the associates. So when I draft agreements for principals, and I do that, they preclude the associate from advising patients or she is leaving the principal's practice. And why do I do that? Obviously, these steps are taken by the principal dentist to protect the goodwill of the practice and to lessen the likelihood that patients will leave with the departing associate dentist. So we've already looked at section 6. This provides, again, that the principal dentist must provide a departing associate's contact information to any patient who requests it. So that this cannot be altered by contractual agreement. So even if you have an associate agreement, if it's you from soliciting, the principal has to tell the patient where you've gone. And as the departing associate, you have to notify the principal in where you're going. And if you don't do that, then the principal have no obligation to notify patients. So when I advise associates, I help them compose an email or a letter to the principal saying, as of this date, or as of May 25, I can be reached at the following address and phone number and practice. Please provide this information to patients. And I always say to my clients, you must be able to demonstrate that you notified the dentist, preferably in writing, or especially in writing, that you've told them. Because what happens, unfortunately, is principal dentists and the staff simply refuse to pass on the information. They're upset, or because they're worried, or the staff think they're helping the principal dentist by making it difficult for patients to find you. But you have to make sure that they pass that information along. And again, it's something that is fairly simple to check up on. You can have one of your friends or your colleagues or family call the office and I want to make an appointment with Dr. Smith. If the staff person advises the caller that you've left the practice, then the caller should ask, well, how Smith? And obviously there are horror stories where, you call for, you are Dr. Smith, somebody calls for you at that old practice of yours, and they say, well, I think he's retired, or I think he's gone away, or he's not practicing, or we don't know where he is, even in circumstances where where they know where you are. And obviously there are lawyers who are designed to address situations where people don't follow the rules, and you think that the principal dentist wants to make it to find you. So when you check up on the principal dentist and you make that call, or your friend makes that call, if the information isn't provided, then you should call RCDS practice advisory and tell them that the principal dentist is not fulfilling their obligations. And in my experience, they will call that principal dentist fairly quickly and call them to account as to why they're not providing the information. So we looked at this before. This is about Section 6 sub C, and it says, except as agreed in writing, you can't solicit, but this doesn't include sending an announcement, announcing the commencement. We looked at this. What does the paragraph mean? I've always interpreted this paragraph to mean that unless the agreement precludes it, that you have a right to insist upon notifying patients who you've treated by announcement of your departure. And if the agreement doesn't preclude it, then you should insist. It's obviously going to help you with your new practice. So what do you do if the principal dentist just refuses to follow the rules? You should have your lawyer write to the principal saying, the associate, you have the right to make this announcement, and we'll make this announcement ourselves if you're not going to make the announcement. And again, this regulation is doing that in the absence of an agreement. You obviously want to make sure that you don't send the announcement to people that you've never treated, because that would be solicitation. All of this information presupposes that you have the contact information for all the patients treated by the associate dentist, right? So how are you going to send people an announcement if you don't know where they are? So in the absence of an agreement stopping you from doing this, I also encourage to try and keep a list of all the patients that they treat, and if possible, their contact information. You want to keep the day sheets or whatever you want to keep. You should keep information that would allow you to contact people, and their email address or their address is probably their email address. Obviously, if a written agreement precludes this, then you can't do this. What does an announcement look like? And this, I've just come up with really basic wording, and you can see the component parts. Dr. Jones and Dr. Chu wish to announce that Dr. Chu will no longer be practicing at ABC Dental. From this date onwards, Dr. Chu will be located at Chu Dentistry 123 Huron in Mississauga. You can stay with Dr. Jones, or you can continue to be treated by Dr. Chu. So it doesn't need to be complicated. As long as you get the message across as to where you are and how you can be reached, that gives the patient the choice of remaining with the former practice or following you somewhere else. I've been talking about the impact of written agreements on these rights and obligations, and the impact can be significant because a well-drafted associate agreement will remove your right to send an announcement to patients, and you'll need to get legal advice on what rights you have to contact you leave. But that right can be taken away from you in writing. So the right to send an announcement can be taken away by a solicitation clause. So what's a non-solicitation clause? as the name suggests. This is one taken from one of my agreements. It basically says the associate agrees that they will not, during this agreement, and that's important because that while you're still an associate, you cannot, and for a period of 2 years following the date that the associate relationship ends, directly or indirectly contact, solicit, interfere with, or endeavor to entice away from the principal any patient of the practice for the purposes of obtaining the business. So that's a non-solicit clause. Those clauses are enforceable. So what does a paragraph mean? You can't contact patients to notify them that you're leaving. So if you have a non-solicit clause, it becomes a bit more difficult to market your new practice. So how do you get around a non-solicit clause? I make the assumption that if patients like you and they like you being their dentist, that when they find out that you've gone, they'll make efforts to find you. So I always say to associates, if you're setting up a new practice, get a website up and running. So the day you leave and you go somewhere else, you have a website that is attached to your name so that patients can find you. The website should obviously prominently use your name so I can Google you and find your new practice location. So non-solicit clauses are useful, but their impact has been diluted by the internet and Google. When I first started giving advice to dentists in the early 90s, there was no Google, internet was in infancy, and they were really effective because you couldn't, if you're the non-solicit clause, how are people going to find an associate? But these days, most people, including me, when I want to make a dental appointment, I just Google my dentist name, and I get the phone number that way. So if patients do that and you have a website up and running, they should be able to find you. So it's essential that you have a website with your name attached so that patients can find you. And it's also possible, even if you signed a non-solicit clause, for you to advertise in newspapers in a specific geographic area. So let's say you practice in Oakville, smaller community, you could advertise in that local newspaper saying, I wish to announce the opening of Dr. David Smith's practice. It also may be possible to do a mass distribution of brochures in a specific geographic region. I don't know whether people do brochures anymore, but they used to. But the point is that even if the non-solicit clause says you can't do any advertising, that's not enforceable. So there are certain things that principals put in associate agreements that aren't enforceable. They do this to deter associates from exercising their rights. So you have to get advice about what's possible and not possible. Which brings me to the next issue, non-competition clauses. So the following is a typical non-competition clause, and I'll explain. Non-competition clauses are clauses which are attempting to stop a dentist when they leave a practice from practicing within a certain geographic radius of the practice they're leaving for a certain, and commonly found in associate agreements. So this is a common non-competition clause. It essentially says the associate agrees that they will not, during the term and for a period of 2 years following the date of this agreement, directly or indirectly, or concerned with the practice of dentistry anywhere within 5 kilometers. So that's a non-competition clause. It's designed to prevent you close to your former practice. This is the type of clause that is not enforceable in a principal-associate agreement. The good news is that non-competition clauses will rarely, if ever, be enforceable. I've been giving advice since the case we're going to look at in Lyons versus Multari for the last years, and I've yet to come across a non-competition clause that's enforceable in circumstances where it's a principal. So this was the case, Lyons versus Multari, established that if a non-solicit would be sufficient to protect the principal dentist's economic, then a court will not enforce a non-competition clause. And again, that's like I said, I've yet to give advice that a non-competition clause in a principal-associate agreement is enforceable. Exceptional circumstances come as yet. So if you're concerned, if you signed an associate agreement and you're worried that non-competition clause, you should seek legal advice as to whether it will be enforceable, because typically those clauses are not enforceable. So you will be able to set up a new practice radius of the former principal's practice. You might ask yourself, well, why are these clauses in this agreement? Like why am I forced to agree to something that's not enforceable? think that principals use non-competition clauses as a psychological deterrent, because some associates may not get legal advice, or they may not get sound legal advice, and the associate thinks they're bound by the non-competition clause, so they don't look to set up a practice within that area. And it's simply not true. Get good legal advice, because by and large, the non-competition clauses are not going to be enforceable. So there was recently a case, a dentistry case that went to the Ontario Court of Appeal, came out very recently. It's a case called Coscarello versus Harvey, a month ago. These dentists were based in Windsor. So the Coscarello case touches on a number of issues I've been speaking about and confirms some of the advice in contacting patients when there's no associate agreement. So the facts. So Dr. Harvey worked as an associate for Dr. Coscarello, the dad, without a written agreement. The practice gets sold to the son, Gennaro. Harvey has to leave. He doesn't have an associate agreement. So before he leaves, he accesses information sufficient to contact patients, the patients he treated in the previous 2 years. He then sends those patients letters, and he's moved practice. And what happens, I think in this case, like 500 or 600 patients left Dr. Coscarello's. So Dr. Coscarello's Jr., Harvey, alleging that Dr. had improperly stolen information and solicited clinic patients. So the type of allegation you'd expect a principal to make. The lawsuit was dismissed at trial, and it was appealed to the Ontario Court of Appeal. And it's rare, like in my world, in the last 20 years, I think there's been one other case involving dentists soliciting and contacting patients. So this is a very useful document, especially if you're an associate that doesn't have an associate agreement. Ontario Court of Appeal upheld the dismissal of the lawsuit. What's interesting is that they agreed the information that Dr. Harvey had accessed about contacting patients was confidential information. And the reason is interesting. It wasn't confidential because he required this to comply with his professional obligation to know the range of location of his practice. Well, where does that professional obligation come from? It comes from that section 6 that we looked at. So the Ontario Court of Appeal was prepared to accept that a dentist has an ethical obligation to tell patients he's leaving. That obligation cannot be executed if you don't have the information to contact. So what the Court of Appeal said is that as part of the associate relationship, there was no records that he was required to keep. Saying that. And the Ontario Court of Appeal had no trouble in finding that he was entitled to access his patient files to allow him to discharge his ethical obligation to contact patients. Because what Dr. Coscarello tried is say, well, you know, Judge, taken this information, those are my patients, they're my confidential information. He can't take that information out of the, and he can't use that information to contact patients. Disagreed and said he, because of they relied upon the RCDS guideline. The court also found there's no legal precedent for the prop that he's not entitled to solicit his own patients. Arguments. The court said absent, there's no prohibition on soliciting one's own patients. And again, it makes sense intuitively, but what they essentially were saying is Dr. Harvey has treated these patients exclusively, 1,000 patients. When he writes to those patients, he's allowed to do that. He's allowed to solicit patients. What this case reinforces and why it's relevant to our topic tonight is the danger in not having a written associate agreement with your associate. So if you're starting a new practice, start as you mean to go, meaning that set up structure, so get associates to associate agreements from the outset. Because as I've said before, the elemental point is the purpose of having an associate agreement is to protect the goodwill of the practice. Without an associate agreement, you run the risk of suffering Dr. Coscarello's fate, which is that a whole bunch of patients leave, and obviously that impacts the goodwill of your practice. The issue comes into play is we talk a lot of who obviously market and sell dental practice. They always ask the selling dentist, the vendor, do you have associate agreements with your associates? Because if you have two senior associate dentists that have been each for 20 years and they don't have written associate agreements, then the practice will be less, because those associates have the ability to leave and take patients with them. So that's, if you want to start a practice and you intend to hire associates in place from the outset, because you never know down the road what's going to happen. So we have a pop quiz question about these issues. And what I'll do is I'll read the question and I'll read the answers, and I understand that Chris will come in and give some information. So this is the question. When leaving an associateship to set up your own practice, are there any restrictions on your ability to contact former patients? So it's multiple choice. A, restrictions in contacting former patients. This is not in the patient's best interest. B, you're only entitled to contact those patients seen 6 months prior to your departure from practice. C, whether or not you can contact patients depends on the terms of any agreement you have with the principal. A written associate agreement may preclude you from soliciting patients. Or D, you can only contact patients who are your friends and family. So leave that question with you. And maybe Chris, let me know if I can give the answer.
Yeah, we have people responding right now, so we'll give just a couple seconds for them to take one final look. All right, I believe everyone has answered at this point.
Okay, great. So can we close that?
Most people chose answer C.
Sorry, yeah, my PowerPoint's not advancing.
Let me close this out and see if we get the control back again. Oh, you know, I think we had this once before. If you take down your presentation and then launch it again, I think it'll work.
Okay. Okay. So the correct answer is 1C. Whether or not you can contact patients depends on the terms of any agreement you have with the principal. A written associate agreement may preclude you from soliciting patients. So obviously that's the answer. Another question, question 2, about soliciting. If an associate has signed a non-solicit clause, does this preclude any marketing of the associate's new practice? These are the choices. Non-solicit clauses are not enforceable in Ontario. B, even if you signed a non-solicit clause, you're still permitted to create a website and do general advertisements and mailings. C, once you sign a non-solicit clause, you're not permitted to mention the existence of your new practice except to your immediate family. Or D, you're free to contact patients to tell them about your new practice as long as you only contact them once.
Okay, we've received many responses now. Most people chose B.
Okay, good. So
Apologies for the need to get out and launch the presentation again.
Okay. So I think everybody got this. Most people got this answer. It's 2B. Even if you signed a non-solicit clause, you're still permitted to create a website, advertisements, and mailings. Okay, great. So I'm going to move to another topic. Business considerations for establishing a new practice. And this will be sort of a brief summary as opposed to an in-depth analysis of some of these issues. Do you incorporate a corporation? So dentists are entitled to incorporate a dentistry professional corporation, requirements concerning the structure of the corporation. And again, the necessary requirements are found in the Dentistry Act and the regulation guidelines under the Dentistry Act. So you need to have a very specific structure and share structure in place in order to be approved as a dentistry professional. This is what you probably know that if you go to the RCDS public register, you can see which tells you which ones are properly. Obviously, whether or not you do, you should obtain advice from your accountant and or your lawyer, advice from. And again, these are general comments. I'm not a tax lawyer, but I know this. Having a DPC provides you with tax advantages, especially if you come to sell the practice. There's the road. And what the issue is that most dental practices these days are share purchases. The purchaser doesn't buy the asset, they buy the shares that owns the assets. The reason they do that is that the vendor, the selling, the ability to take advantage of the gains used to be up to $750,000. So you can shelter that much money. And again, I don't take my accounting advice. This is my understanding what drives these transactions. You can take advantage of a properly set up DPC. I then wanted to talk about employee contracts for new employees. And again, I'm trying to give you advice about structures starting out, legal structures that can protect the road. So we'll assume in your new practice that you're employing people, and it's essential that you at least consider the issue of having employment contracts for employees when you start, because this can result in significant savings and elimination of future problems down the road. Why is that? The benefits, we need a brief primer on wrongful dismissal. So the law provides in Ontario that and in Canada, employees who are dismissed from employment are entitled to be provided with notice of termination or payment in lieu of notice. We call it termination pay or severance pay. The notice comes from this obligation, two different places it comes from. There's statutory notice under the Employment Standards Act. So you've heard of that. The Employment Standards Act is provincial legislation that sets out statutory minimums that you have to, as an employer, have to pay employee if you dismiss them without cause. And secondly, the common law notice as established by the courts, and that's really the much larger obligation. So just dealing with the Employment Standards Act, it stipulates a minimum notice required. And this is what minimum notice is. It's fairly straightforward. Less than 3 months, no notice. 3 months and 1 year, 1 week, 2 weeks, 3 weeks, so on, up to a maximum of. So under the Employment Standards Act, if you have a working for you for 25 years and you only have to pay them 8 weeks pay. But unfortunately, that's not the only obligation. There's the common law. So the ES outlines the minimum notice requirements. The common law is much more generous about this. So what is common law? It's judge-made law. So if an employee sues you for wrongful dismissal and you don't have an employment contract, you end up with a judge. The judge is going to give much more than 1 week's notice of employment. Defined rule as the employee is entitled to, but courts are much more generous to employees who've been wrongfully dismissed. Rough rule of thumb, and you will have all heard of this, I know by now. A very rough rule of thumb, courts will award dismissed employee approximately 1 month's pay per a maximum of 24 months. So the longer an employee works for you, the more severance at common law they're going to be entitled to. Now, they also look at the age and employment. So managers get more than people who aren't managers. People who are older, their philosophy is if I'm a 65-year-old and I'm not good with technology and I've worked in your 15 or 20 years, when I leave, I'm going to have a more time getting a job. So the law recognizes that. So they say leaving secure employment more than people who've only been there for a short period of time. Well, how do employment contracts help? So employment contracts allow you to avoid paying this common law to dismiss. A properly drafted employment contract can limit the amount of notice you have to provide to the minimum under the Employment Standards Act. So we look at the minimums. It's 1 week a year up to a maximum of 8 weeks. So if you have properly drafted employment contracts, the potential savings can be quite. And the illustration of, you have an employee who's been working in a dental practice for 24 years and earns $1,000 a week. Obviously, lots of more than that. Hygienists earn much more than that. So I've taken a conservative figure. So if no contract's in place and you let that person without cause after 24 years and they sue you, under the common law, the employer will be liable for up to 24 months' wages, 104 wages, $4,000. So that would be exposed to if you let go of this long-term employee and you contract. So if you have an employment contract and it limits your obligation to the ESA minimum, the maximum payable 24-year employee is 8 weeks pay. So this would be $8,000. So this results in a potential savings to the employer, $6,000. And again, I've used an example that is dramatic because it illustrates the point. But this happens even a 5-year or 10-year employee, and I deal with these in these calls every day. If somebody's been there for 10 years, they're let go without cause, entitled to up to 10 months pay. If there's a contract, then they'd be entitled to the 8. And in terms of the flexibility, if you have an employee who's difficult or performance is deteriorating, or for whatever reason they're not working out or they're not suitable, and let them go, if you have an employment contract, you can do so without breaking the bank. But if it's a long-term employee, you don't have an employment contract, you may have to suck it up and deal with the person's poor performance, poor attitude, because it's just going to cost to let them go. Now, it is possible to give them a topic which I won't get into today, but I want to focus on employment contracts. So this is the benefit. You avoid paying that common law severance. And it's properly drafted. The termination clause allows you to limit to the ESA minimum. So I always say every dental practice owner should use employment contract. And again, I know from dealing with brokers like Tier 3 and others that when they go to vendor of a dentist, they always have to have a discussion about employees. How many employees do you have? Do they have employment agreements? Because if you're the purchaser and there's 10 long employees, none of which have agreements, you won't want to offer employment to those employees because you'll be walking into a situation where you could be looking at a large severance payments. And my clients sold a dental practice and there were 2 long-term employees. They didn't have agreements. And I think we ended up paying 24 months and 15 months wages to the other one. And obviously that comes out of the bottom line. So when you're considering selling your practice, you don't have employment agreements. If the purchaser says, I'm not taking these people, then you're dealing with these obligations. So keep that in mind when you set up your practice. Signing a lease, again, I'm not a lease lawyer, but I'm assuming you need to rent premises. You have to get decent advice. And I know that there are lawyers that do this work, but there are also decent lease consultants who serve the dental industry and can provide advice and assistance in negotiating a lease. You want a lease that has lease extension clauses. So if you spend a great deal of time and money building out, then you need to make sure that you can stay there for more than 5 years. And what I've been told by my friends who do corporate law for sales and purchases, banks will not extend financing to a new dental practice unless the lease commitment 12 years. And it makes sense. Like if they lend you a large sum of money, millions of dollars, then they want to make sure you'll be financially viable and you can stay in that location for a period of time. There's something called a demolition clause that you see in leases that essentially gives the landlord the right to demolish the premises under certain circumstances. Don't want to be in a position where the landlord comes and knocks down after you've spent lots of money renovating. So get some advice about this, think about it, make sure you understand what your rights and obligations are, or at least have a plan in terms of how you approach them, understand these issues. Choosing a practice name. I always say dentists are highly regulated, and the RCDS has their thumb on you on many issues. One of those issues. So of course, their name for your practice, you have to seek the approval of the RCDS. They have a very specific process to consider these practice names. This is the practice advisory that describes what it's about. Practice names fall into two different categories, essentially. The first category is names that are referable to the location of the practice. So these don't need to be by the executive committee. So if my dental practice is Port Credit Dentistry, then I don't need to get approval executive committee. Fancy name like Harmony Dental or Transcendental Medication Dental, whatever. These other types of practice names must be approved by the executive committee. But either way, for both these categories, you have to complete an application for practice name, an application you can find on the college. The RCDS guideline provides that practice names should not include the use of descriptive terms to describe the practice, the practitioner, the equipment, expected treatment, or any other practice. So you can't call yourself best dentist in Mississauga dentistry or anything that describes the type of dentistry that you're going to do. And again, this is one of the dentists are really tightly regulated, and we're going to get into the discussion now about advertising as well. And it's quite heavy, like many other professions. So when you're choosing a practice name, it's not just about contacting the RCDS. You have to get your lawyer to search that name. There's something called the Business Names Registration Act. It's an Ontario statute that uses practice names to register the names. The purpose of registering that name is to provide notice to the world in case somebody else wants to use that name. So you have to do a Business Names Registration Act, choose a name that another dental practice has, similar to another dental practice. And I've had 20 years where my client's dental practice name is to another dental practice. Presumably they didn't do the search that I'm suggesting you need to do. And in one case, there was a lawsuit. In other cases I've had, the other more established sends a letter to my client saying, you're called Junction Dentist, Junction Dental Clinic. These names are too similar. If you don't stop the name, we're going to sue you. And because it's causing confusion. So there is a tort, and a tort is simply a legal word for civil redress. So if you commit to be sued. So the tort is called off. It's applicable where one dental practice has chosen a name very similar to dental practice, and there's confusion because patients don't know whether they're going to the more established practice, other practice, and essentially it's called passing off. The newer practice is passing themselves off as the older practice. So it's just a description telling you what's going on here. Obviously, you don't want to spend a huge amount of marketing and time and money and signage a name that you have to change. And keep this in mind, the fact that the RCDS has approved your practice name doesn't eliminate the risk that you've chosen a name that's similar to another practitioner's practice. That's why you have to Registration Act search. So if you have a name in Registration Act search, you apply to the through the RCDS application process, then you should be okay to use that name. But you have to take those steps. You really don't want to shoot yourself in the foot right off the bat by choosing a name that you have changed after you've set up your practice, done your advertising, told people what your name is, and put up an expensive sign. So this is pop quiz question number 3. Are there any restrictions placed upon an associate's ability to choose a new practice name? A, you're free to choose whatever practice name you want. It is a free country. Spoiler alert, it's not a free country if you're a dentist. It's not going to be that easy. B, you're free to choose any practice name whatsoever, as long as it is in good taste. C, you need to obtain the approval of the RCDS. In addition, you need to be careful not to choose a name that's already been used by another dentist. And D, you're free to choose any practice name so long as the practice name does not use any ethnic terms. So I'll leave that with you to let you answer that question.
All right, Matt, you had some very good attendance and listening skills here on this one.
Good. Maybe the answers were too silly. Oh, look at that. Very good. Okay, well, I'm going to get the answer. And of course, everybody got this one, almost everybody. C, you need to obtain the approval of the RCDS in respect of your new practice to choose a name that's already been used by another dentist. Talk about advertising, setting up a website and conducting advertising. Dentists are restricted in the advertising that they can do. There's a professional advertising guidelines, and there's also a regulation as well. And it's going to be frustrating for you, because what you'll find, and what clients repeatedly tell me is, what do you mean I can't say this? I could go online and show you 10 different dental practices that have websites that are breaking these rules. Why aren't I allowed? Well, I always say you can, but you're coming to the proper advice, and I'm telling you that the advertising guideline. So this is a professional advertising guideline. There's also a specific section of the professional misconduct regulation that describes what you're not allowed to do. Some of it makes sense. So this is an excerpt from the regulation. So what this basically says is an act of misconduct if you advertise, you include information that is false, misleading, fraudulent, ambiguous, or confusing, or is likely to mislead the public because it makes only partial disclosure of relevant fact. Again, obviously you don't want to be false and deceptive. This makes sense. Some of the stuff is more difficult to get your head around. Like B, you can't advertise in a way that is not relevant to the public's ability to make an informed choice. And again, that this is real hair splitting, and I'll get to some examples of this in a minute. C is not verifiable by facts, or can only be verified by a person's beliefs, opinions, or interpretation. Again, this is a very esoteric. I know that dentists have a hard time getting their heads around what this is about, but we'll come to some examples. Again, these are other aspects of the regulation. You're not allowed to make comparisons with another practice, or make suggestions that would reasonably be regarded as suggestive of uniqueness or superiority, or you're not allowed to make statements that are likely to create expectations of appeal to the public's fears. And again, that seems crazy, doesn't it? You're not allowed to advertise in a way that makes people get good service from you. I mean, it's restrictive, and it's frustrating, because why are you advertising? You want to create the expectation of a favorable result, but according to the RCDS, you're not allowed to. So how do you ensure compliance? There's no substitute for reading and following the regulation. But I wanted to go through some examples of one of the things that happens in this, before I look at the specific examples. My client comes to me and says, I've received a letter from the RCDS. They don't like my advertising, but it wasn't me, it was my consultant. And so I don't think I'm responsible, because I didn't make this decision. I paid somebody else. It really doesn't matter. Your consultant is regulated. They don't have a license to defend. You have a license to defend. So responsibility for your advertising, from a legal standpoint, according to RCDS. So you should take responsibility de facto of reviewing what you're doing. So what are you not supposed to do? And I could go on all night about this, but you're not supposed to include material that would be considered violation. So statements which are unclear, untrue, or misleading. And I think we all know what that means. If you say, I can give you a completely new smile for $2,000, that's misleading. That's probably not true. And it might work in 1 in 1,000 cases, but it's not likely. It's misleading, right? Statements that are indicative of superiority or uniqueness. And this is where dentists come afoul often. Examples of such statements would be, we're the best cosmetic dentist in Mississauga. We have the best trained prosthodontists in the GA. Or statements like, Dr. Jones is president of the ODA. Dr. Smith has taken multiple continuing education courses in cosmetic dentistry. Dr. Smith is the president of the Mississauga Crown and Bridge Club. So these types of things are not relevant to a patient's ability to choose. That you're not allowed to say this. And I know you'll be thinking, well, I've seen websites where dozens of people say this, but from a legal standpoint, they're not supposed to say that. Suggest or create an expectation of favorable results or appeal to the public's fears. So if you say, I guarantee we can fix your gum problems within a month, that's obviously something that creates an expectation that really isn't reasonable. Guarantee we can improve your smile 100% for reason. Maybe you can in one case 20, but you can't guarantee every person their smile improved at 100% for a reasonable cost. Appealing to the public's fears could be indicating stuff like if you don't get your gums checked, life expectancy, or other fearful things that you say to them. If you don't get teeth cleaning regularly, dangerous bacteria may cause you serious illness. That may be true. The thing is that some of these statements might be true, but they're designed to scare people and they're not permissible. That's the irony about this. That may be a true statement for some, but it's not permissible. The other one is testimonials, right? So a testimonial is a patient saying, I saw Dr. Jones and she was great and she's amazing. I'm not supposed to post testimonials. Now, I see testimonials on dentist websites all the time, but they're not allowed. Now, I think there's a gray area in respect of, let's say you had a link to Google reviews. If you have good Google reviews, you're typically not testimonials, so you might be able to get away with that. The other strange one is any statements that can only be verified by a person's personal feelings or views. So the testimonials are easy to understand, but you can't post statements saying how satisfied a patient is with your dentistry. You can't say, Dr. Chu is the best dentist or we are the nicest and kindest dentist in Brampton. Those statements can only be verified by subjective personal feelings or views. So it's hard, right? I mean, these are difficult concepts. You're trying to be creative. You've just spent millions of dollars setting up a practice, and you have both hands tied behind your back because you can't advertise a certain way. You can't advertise sensationally. You can't have giveaways. There's all kinds of other, like I said, I could go on for an hour about advertising issues, what you can't do. But tonight, say, look into these issues, be aware, don't make any mistakes. Get the call from the RCDS. This is another one that's really common. Don't include that suggest super or comparative terms. And I see this all the time. We have the state-of-the-art, diagnostic, cutting-edge lasers, up to deal office. Any other words suggest, that your place is better than somebody else is not permitted. And again, you're saying, well, isn't that what advertising's supposed to do? Aren't we? Why does everybody else get to say, well, we're the best butcher in Port Credit? We're not allowed to say we're the best dentist. No, you're not. And I said, the frustration is that the guidelines are breached routinely by dentist websites because dentists love to say, you spent all this money on this equipment and building out this fab office. And you love to say, look, I have the latest technology. I've got all the shiny new stuff in my office. On the law, based on the regulation, these kind of statements are forbidden. So what happens if you don't? And what happens? What's interesting and entirely predictable is that dentist advertising issues don't call up and say, Dr. Leung is using superlative terms. Leung says he's got the best lasers. That's a breach of the advertising guidelines. The patients don't care about this. So what invariably happens is it's another dentist, right? Another dentist has listened to a speech like mine and says, well, wait a second, that advertising is not kosher. The overwhelming majority of these advertising issues that the college investigates, as another dentist has complained because they're jealous or because they don't want you to do well, because they think you're doing what you do. So the RCDS does have a process to investigate, and it's not treated like you're familiar with patient complaints, probably. Patient complains, you have to provide a response, you have to send the records, and then the ICRC, which is the name for the complaints committee, decides. They deal with this in a separate silo, and they do. So what they do is they usually have a dedicated staff member who is to police advertising. And what they do is they call up or they write to the dentist and they say problems with your advertising, what it is, and then you're given the whatever problems. So it's not punitive in terms of in this the patient place can be punitive. So they'll tell you what you've done wrong, and then what you have to do is change your advertising. It's just a no-brainer that you have to change it. So if they tell you your advertising is wrong and you say no, disagree with you, then they will escalate the matter, right? So they have the ability to escalate them. They have to investigate to start what is known as a Section 70 investigation. Then it ends before the complaint may lead to punitive consequences, including caution, and that caution going on the public register of the RCDS website and remaining there. So is, when they come to you and they tell you something's wrong, then you have to listen, you have to take the advertising down. So one final pop quiz question: what restrictions are placed upon a dentist's ability to advertise? A, the RCDS has advertising guidelines and a specific regulation that deals with advertising. B, there are no restrictions on your ability to advertise other than good taste. C, you're permitted to advertise, but only in reputable publications. And D, advertising is strictly prohibited. So I'll let you answer those questions. There are some very optimistic answers up there, so I'm sure you'll spot those and know those aren't the right ones because you've been listening and I've told you how heavily regulated you are.
Okay, we have most answers in now.
Okay, yeah, I mean, that wasn't a tough one. So those are my comments for this evening. I just wanted to explain as a litigation lawyer who's acted for dentists for a long time, I see what goes wrong, and everything is a risk-benefit analysis. Some dentists will say, well, I heard the lawyer tell me I can't do this, but I think I'll take the chance and maybe I won't be the one that gets called on the carpet. But in my job, I always see all the cases that go wrong. I spent this morning at the RCDS Discipline Committee with a client of mine that took chances and got caught. So I tend to give cautious advice, but as I said, it's a very regulated profession, and you need to be careful and you need to sort of be aware of these issues, because one or two of these issues can cause you a loss of momentum for your practice when you start. So those are my comments for this evening. I think there may be some questions, I'm not sure.
Thank you, Mr. Wilton. That was really great. You provided some very practical guidelines for our associate and practice owner to manage their risk. It reminds us of the importance of proper planning and that the best advice is the act now. Okay, so we have a couple of questions over here, and I go one by one. The first question we have: I am an associate who is planning to buy a practice soon, most probably within the next 2 months. My associate contract prevents solicitation of staff and patient at my practice, but my front desk staff, who knows that I am leaving, has been planning to quit for a while and has asked me if I would consider hiring them. Am I allowed to hire them even if they quit on their own without any solicitation on my behalf?
So, I mean, it's a question that the answer to which depends on the exact wording of the non-solicit clause. So if you don't solicit that employee and they come and they apply to you after the fact, then that would be fine. But it's often a matter of proof, right? So I'm a litigation lawyer. So if I was on the other side of the case, I'd say, well, how did you find out about the job? What communications did you have with that person before they left? You have to make sure that you're scrupulous and above board and open up your new practice, and then have them send an application form, send a letter to you saying they want to work for you. You can't make plans in advance, and you have to be really careful. Like this is one of those issues where, and again, I'm not telling people to get legal advice to generate files. I'm just saying get some legal advice, whoever it's from, before you take these steps, so that you can eliminate the risk or lessen the risk that the perception is created that you hired that person away. Excuse me.
Next question we have, do you need to set up separate corporation for each practice you set up, or just the DPC for all practice location?
I mean, and again, I'm not a corporate lawyer, but I mean, what I've seen is that I have clients who own multiple practices and they only have one DPC, but whether or not that's the right thing for you depends on your structure and your tax issues. So my short answer is one DPC could own more than one practice, but whether or not that's right for you may be driven by business considerations separate and apart from the fact that one DPC can own 3 practices.
Can hygienists be considered as independent contractor if they are incorporated?
This is a difficult issue, right? So independent contractors are different than employees because employees are subject to the Employment Standards Act. The Revenue Canada and Service Canada over the years has targeted dental hygienists who are paid as independent contractors, but they only work in one office and they don't have what lawyers call the indicia of independent contractors. But if you have a dental hygienist that works for you and they have a corporation and they work in 2 or 3 other offices, then it's more likely that they might be considered an independent contractor. But if they only work in your office and they've incorporated because it suits them from a tax perspective, you run the risk that Revenue Canada will come along down the road and say, well, they're not really an independent contractor. They only work in your office. They have none of the indicia of being an independent contractor. They're not in business for themselves. They might as well be an employee. So again, it's a contextual analysis, but you have to be careful. I've had cases, I got a case about 10 years ago where Revenue Canada came to a dentist and said, well, your 3 dental hygienists are not independent contractors, even though you pay them as independent contractors. And what happened is the dentist had to then pay a bunch of back tax that one of them hadn't paid. And you also set yourself up to have to pay like statutory pay and public holiday pay, vacation pay to people because they're deemed after the fact to be an independent contractor. So again, it's one of these classic legal issues. It's all context driven, but you have to be careful.
And we have the last question over here. My previous employer is significantly delaying payments and withholding collection under the work whole book policy. I ended my employment on December the 15th, 2024. Yet they claim only a small fraction of my billings has been collected, despite clear evidence of production. They are also pushing me my whole back payout a full year after termination. Does this violate any RCDS or labor regulation? And what step can I take to recover my earning?
So it doesn't violate any RCDS regulation. It doesn't violate any employment regulation. And it all depends on whether you have what the associate agreement says. Let's assume there is no associate agreement, or even if there is, if they haven't paid you, then you have the right to sue them, right? So I deal with these cases all the time, but there are some practical realities about retaining a litigation lawyer. So if you're owed $10,000 or $20,000, I find it's a common bad habit that principals have. They know that you may not want to sue for $10,000 or $20,000, so they don't pay you that last $10,000 or $20,000. But you have the right to the following: you have a right to an accounting of all of the monies they've collected on your behalf, and you have a right to be paid your percentage of what they've collected. So if they're not telling you anything, then you can, and I do this all the time. I've got probably half a dozen lawsuits like this right now for associates against principals. You can get your lawyer to write a letter to them saying, it's been this much time. I have information suggesting that you've collected a lot more than you're telling me. And if you don't pay me now, I'm going to sue you. And again, that can be effective, or it may not be effective, because some dentists or some principals are incredibly unscrupulous. I have a couple of cases where the principal's entire modus operandi for business is to stiff people, to not pay the associates. So there's like a dozen associates that haven't been paid, and a number of employees that haven't been paid as well. So it's a problem, right? Because once you get into a dispute with somebody that has a lot more money than you, then you have to make sure that you're not spending money that you won't get back.
Fair enough. We just got another question. Can an associate dentist who works only out of one dental office be considered an employee?
Typically not, because the issue of employment and versus independent contractor is driven by control issues as well, right? So if I'm an associate dentist, you don't stand at my elbow and tell me how to do a filling. So dentists are typically not employees, but there are dentists who have employment agreements. So it all depends on the facts, right? I know that like dentists who work for public health or dentists who work in dental clinics run by labor unions, et cetera, they're often paid as employees and not independent contractors. It all depends. I mean, it's not unheard of, but typically the average associate will be an independent contractor for the reasons I've suggested.
Sure. I think we have all this question. Chris, did we missing any question?
No, Kieran, we have answered all the questions this evening.
Oh, that's great. So thank you, Mr. Wilton. Well done. Thanks for sharing your great knowledge with our dental community. I hope your colleagues were able to gain new insight into approaches for risk management. If anyone has the further question for Mr. Wilton, feel free to contact him directly by email to mwilton@wmlitigation.com. I would like to also remind, yes, sir. Go ahead.
Sorry, I just wanted to say if anybody wants a copy of my slides, to the extent they might have information, then just drop me a line as well, or ask Chris or Kieran.
Okay, thank you, sir. Yeah. I would like to also remind our guests that TMFD specializes with dentists and understands the challenges you face on regular basis. Whether it is a tax and accounting business issue or personal financial planning, we are here to coordinate and simplify your affairs. If you have a question, please contact us at info@tmfd.ca. I would like also thanks everyone for joining us this evening. We hope you enjoyed it. In the days following the webinar, a video recording will be posted on our website, tmfd.ca. You will also receive a brief survey asking how you enjoyed tonight's presentation. So please share your feedback. Please tell your colleagues about TMFD Dental Academy. We love them to join and gain from the collective knowledge to be shared. A reminder that PACE credit will be issued within the next 2 weeks. TMFD will be hosting additional webinar later this year. So please look for this announcement in the days ahead. As we close up this evening, I would like to thank you, our speaker, Mr. Matthew Wilton, for his valuable expertise and insight. And thanks to you, our guest. It's a really great share this evening with you. We hope you will find it valuable. Thanks again, everyone, and have a good night.
Good night, everyone.
Good night.